Good day, ladies and gentlemen. Welcome back to another What If video. For those of you who don't know me, my name is Viapia, and today's topic is what if an employee is sexually harassed at the workplace? What are the risks for employers? Now, firstly, in terms of the Employment Equity Act, harassment of an employee is regarded as a form of unfair discrimination and is prohibited on the grounds listed in the Act. So, for example, your race, your gender, or your sexual orientation. Sexual harassment remains, as we speak, one of the most common forms of discrimination in the workplace. We also have a code of good practice on the handling of sexual harassment cases in the workplace, and what is important is that sexual harassment is defined in this code. This definition, or sexual harassment's definition, is any unwanted conduct of a sexual nature that violates the rights of an employee. Now, this unwanted conduct, ladies and gentlemen, can be physical, it can be verbal, or it can even be non-verbal. The unwanted nature of sexual harassment distinguishes it from the behavior that is welcome and mutual. The question is, what does the law require an employer to do when an employee claims that he or she or they have been sexually harassed? And then obviously, what are the risks if this takes place, or if an employer does not do what they are expected to do? Now, firstly, the employer should inform the employee that he or she or they have a choice of either addressing the matter in an informal or a formal manner. Now, this is also normally included in a company's policy, sexual harassment policy specifically. The code also prescribes employers to have a policy in place. Now, back to the informal approach. The informal approach entails the complainant personally or through an intermediary confronting the alleged offender and explaining that the conduct in question is not welcome, that it offends the complainant, it makes the complainant uncomfortable, or it interferes with the complainant's work. The employer should also confirm and discuss with the employee what assistance, if any, the employee requires from the employer in order to address the matter in an informal manner. Now, if the informal approach fails to provide the desired outcome, or where the complainant chooses to follow the formal route, or where the harassment is of such a nature and gravity that the informal approach would be inappropriate, the formal approach should be embarked upon. The formal approach entails that a formal grievance is lodged by the complainant, with the result that the company has to become formally involved in the matter, including, and this is important, investigating the matter. Now, should the investigation show that sexual harassment was likely to have occurred, the employer will have to take appropriate disciplinary action against the offender, which, depending on the nature and severity of the harassment, could result in the offender's dismissal, even or if found guilty on a balance of probabilities. What we see a lot, ladies and gentlemen, is that the complainant comes forward and says that they don't want any action to be taken against the alleged offender. That investigation that one needs to do or take is irrespective of the victim or the complainant's wishes. So if there is a complaint of sexual harassment and it's not being dealt with informally, then the formal approach is to investigate it irrespective of the wishes of the complainant, because there's an obligation on the employer to create a safe workplace. Other than that, employers should also ensure that the utmost confidentiality is maintained during any investigation into an allegation of sexual harassment. Any information concerning the matter should only be shared as is reasonably required with those people that are involved in the investigation. The consequences of sexual and other forms of harassment can be dire for employers. Now, what does this entail and what does this mean? Number one, if an employee can prove that they resigned because sexual harassment has made continued employment intolerable, this employee can pursue a claim for constructive dismissal under the Labour Relations Act. This will usually be the case where the employer didn't take appropriate action to deal with the problem. So the employee came forward, made the employer aware, HR or the manager aware of the alleged harassment, but the employer did not deal with it in an appropriate manner, the employee resigns, now goes to the CCMA and claims constructive dismissal. Number 2, the employee could have a separate claim under the Employment Equity Act if it is proved that the employer failed to take what they call reasonable steps to prevent or deal with sexual harassment after it was brought to the employer's attention. If this is the case, ladies and gentlemen, Section 60 of the Employment Equity Act states that the employer will be deemed to have contravened the Employment Equity Act. In other words, if it has been brought to the employer's attention and the employer does nothing or doesn't take reasonable steps, the Employment Equity Act states that if that is the case, the employer will be deemed to have contravened the Employment Equity Act. Now, should the employee be successful in this claim, the Labour Court or sometimes the CCMA can award an amount of compensation to the employee that it deems fit and appropriate under the circumstances. Also, where one employee sexually harasses another, or for example, an employee harasses a member of the public or a customer, the employer may face an additional claim for damages on the basis of so-called vicarious liability in terms of the common law. It is important to note that an employee can, in appropriate circumstances, institute an unfair dismissal claim, an unfair discrimination claim, and a claim under common law for the same harassment and receive compensation in respect of each claim if successful. The harasser, on the other hand, faces not only disciplinary action, which the employer should take against the harasser, but which includes possible dismissal, but also faces a potential civil claim by the victim. In appropriate cases, criminal proceedings even may be pursued against the harasser. These actions, however, have no direct impact on the employer from a sexual harassment point of view. Also, when an employer investigates a complaint of sexual harassment and it is established that the complainant made false accusations against the alleged offender, the employer may obviously take disciplinary action against the complainant, which may even include dismissal. We have been involved in some of these cases where we have found in our investigation that the complainant made there was no grounds or no evidence to support the allegation. Ladies and gentlemen, that then brings us to the end of this video. As I've mentioned, there are various steps that employers need to take when dealing with a matter of sexual harassment. And step 1 is to have a proper sexual harassment policy in place. If you need any assistance in this regard, please do not hesitate to contact us. Until next time, bye-bye.